Hey everyone, and welcome to This Explainer. If you've been scrolling through the news over the past couple of years, you've probably noticed a really fascinating shift. High-profile corruption cases are being handled totally differently, and in some big instances, they're actually being overturned. Today, we're going to dive right into exactly why the U.S. Supreme Court is actively redrawing the precise lines of what actually counts as federal corruption. So let's just jump right into it. When does political access actually cross the line and become a federal crime? It sounds like a pretty straightforward question, right? But here's the thing. When we try to treat the law as this giant, broad code for ethical government, we actually end up blurring the lines between normal, everyday political influence and, well, actual criminal responsibility. Let's be real, influence is literally everywhere in politics. But drawing a strict legal circle around what makes something a federal crime, that requires absolute precision. To wrap our heads around these shifting boundaries, this explainer is going to walk you through 4 major Supreme Court rulings between 2023 and 2025. We'll quickly cover the vague rules of corruption, define duty and property, compare bribes to gratuities, show you how a corruption case is built nowadays, and finally, look at the real-world compliance playbook.
All right, part 1, the vague rules of corruption. Let's look at why these boundaries have been so tough to nail down in the first place.
Well, it turns out federal anti-corruption law in the U.S. isn't just one neat, tidy rulebook. Instead, prosecutors rely on this massive, overlapping, and honestly kind of tangled framework. I mean, you've got bribery offenses, honest services fraud, property fraud, extortion, all the way down to money laundering. Now, this setup definitely gives investigators plenty of different angles to tackle corruption, but it also raises a huge recurring question. Just how far can these really broadly worded offenses legally reach into local government, private lobbying, and everyday commercial deals? Which brings us to part 2, defining duty and property. Let's head back to 2023. The Supreme Court tackled these exact concepts in 2 massive cases connected to New York's Buffalo Billion Initiative. Take the timeline of Joseph Percoco. He was a senior aide to the governor of New York. Now, in 2014, he temporarily left his government job to manage the governor's re-election campaign. While he was working that private gig, he stepped in to help a development company by pressuring a state agency to drop a specific labor requirement. After the election, he just went right back to his official government role. Well, prosecutors slapped him with honest services wire fraud, arguing he used his heavy influence while temporarily acting as a private citizen. So why did he intervene in the first place? Well, that development company happened to arrange 2 payments totaling $35,000 to Percoco's wife. Because of this, the trial court told the jury that Percoco had a special relationship with the administration, and his massive political dominance meant he effectively owed a fiduciary duty to the public, even though technically he wasn't on the government payroll at the exact moment he made the call. That is a pretty massive legal leap, right? Well, the Supreme Court stepped in and basically said, no way. They rejected that special relationship test entirely, calling it way too vague. Their argument, our political system is absolutely full of influential private citizens. You've got lobbyists, former officials, political strategists, you name it. If you turn undefined political influence into a strict criminal duty, you fail to give people fair warning about when their everyday access suddenly becomes a federal crime. To be clear, they aren't saying private citizens can never owe a duty to the public, but the legal standard has to be way more precise than just vaguely having a special relationship. Okay, meanwhile, in a second case from 2023, the Ciminelli case, the court had to define the word property in a situation about rigged procurement bids. The government based their whole conviction on this thing called the right to control theory. Basically, this theory claims that a victim is robbed of their property if deception denies them economically valuable information that they need to make informed decisions about their assets. In plain English, tricking someone out of valuable info is treated the same as physically stealing their cash. The Supreme Court unanimously struck that down. They ruled that an abstract right to accurate information is absolutely not traditional money or property. Expanding federal fraud to cover any undisclosed conflict of interest or commercial deception goes way, way beyond traditional property rights. If they allowed that, federal prosecutors would be pushing into territory that is usually handled by state and contract laws. It was just too broad. But hold on, because just because information isn't property doesn't mean anything goes. Fast forward a bit to the 2025 Cousikas case, and the court drew a really crisp boundary. In this one, a contractor lied about using a disadvantaged business supplier just to win a government contract. The painting work completed perfectly. The government got the exact physical value they paid for. But the court said, nope, this is absolutely federal wire fraud. Why? Because while info alone isn't property, using false promises to grab actual contract dollars from the government is a crime. The actual government money was the direct target of the scheme. All right, moving on to part 3, bribes versus gratuities. The court kept sharpening these definitions in 2024, zooming in tightly on the timing of corrupt payments in Snyder, the United States. It literally all comes down to timing. Under federal statute section 666, a bribe is a pre-planned corrupt exchange. The payment is agreed upon to influence official conduct before the act happens. A gratuity, on the other hand, is just a reward given after the fact, without any proof of an earlier agreement. The court ruled that this specific federal law simply does not cover after-the-fact gratuities. Now, to be clear, this boundary drawing doesn't mean gratuities are suddenly a free-for-all. You can't just go handing out cash rewards to officials left and right. It just means prosecutors can't use this one specific federal statute, Section 666, to punish rewards when Congress didn't explicitly say they could. State ethics rules, local laws, and internal workplace policies, they can, and absolutely still do, ban those kinds of gratuities.
So, part 4, constructing a corruption case.
Because the Supreme Court is now demanding such intense legal precision across the board, investigators can't just wave their hands at broad ideas of dishonest government anymore. They have to build their cases incredibly meticulously. It is like a giant puzzle. You need a precise, step-by-step chronology. You have to clearly define the exact duty or property interest right from the start, so again, no more vague special relationships. You've got to trace the communications to prove the intent of a corrupt exchange, and follow the money through any middlemen. And finally, you have to test any legitimate explanations. Basically, prosecutors must prove an undeniable link between a specific statutory offense, a defined duty, and a corrupt exchange. Just pointing at suspicious political access isn't going to cut it anymore.
Which brings us to our final section, part 5, the new compliance playbook.
So, what does this super precise legal landscape mean for corporate compliance and financial crime leaders out in the real world? Well, institutions need to build a really resilient, multi-layered control stack. You can't just glance at someone's current job title and call it a day. You have to map out relationships across changing roles, just like Percoco bouncing from the governor's office to a campaign and back. You have to rigorously document the commercial purpose behind every single payment made to politically connected folks, and you absolutely need ironclad evidential traceability to prove your actions were completely legitimate. Ultimately, if there's one key takeaway for organizations, it's this. The strongest operational response is greater precision. The Supreme Court isn't saying unethical behavior is okay now. Let's be crystal clear on that. What they are doing is demanding that both prosecutors and corporate compliance teams stop leaning on vague ideas of fairness and start operating with exact precision. You need to know exactly who owed the duty, what specific property was targeted, what actual benefit changed hands, and exactly which legal framework applies to the whole shebang. I want to leave you with this hypothetical. If your organization was investigated tomorrow, could your control stack clearly distinguish legitimate political advocacy from a federally defined corrupt exchange? Because in this newly redrawn legal landscape, treating every commercial relationship like it's criminal is honestly just as dangerous as failing to spot the actual corruption hidden in the details. Precision is your best, and really your only defense. Thanks so much for joining me for this explainer, and remember to always keep questioning the details.